It's really so stupid. A slanted justice system, high incarceration rates, record unemployment, voter disenfranchisement, racism. So to help me dig in to just some of these issues, I'm joined by the president and CEO of the NAACP, Ben Jealous. Trayvon Martin is something else that really profoundly showed the state, the underlying state of just racism in this country. Yeah. What do you think this really revealed about, you know, here we are, it's kind of something that's under the radar, but it really is pervasive.
You know, this is a problem, and if we're honest, frankly, we see it throughout the West. You know, when I travel to Switzerland or to France, you see young men from North Africa being treated exactly the same way. If you're in London, you see young men from Jamaica being treated the same way. Where basically young men of color are treated as criminals just for being of color. And we have these stand your ground laws in this country, something that you don't see really outside of the U.S., that allows people to racially profile with lethal force while walking down the street. Because what it says is if you fear that somebody's about to do you bodily harm, you can shoot and kill them. Well, there's a lot of folks, unfortunately, who are just afraid of men like me, men of color, simply because of how we look, because we're a little darker, because we have a beard. And it gives them license to racially profile with lethal force, and that's what we're fighting against.
Before I introduce our first speaker, I do want to take just 3 or 4 minutes to lay something of a foundation for our discussion this afternoon. To put the controversy over the stand your ground laws into some perspective, I think it's necessary that we first take a look at another law that Florida enacted in 1987, and that was their law regarding concealed carry permits. 25 years ago, it was illegal in many states for ordinary citizens to carry guns outside of the home if they did not have a permit. At that time, the permit systems were a discretionary matter with the police. If you couldn't persuade the local police department that you needed a gun for purposes of self-defense, that was the end of the matter. There was really no practical appeal from that denial. But Florida adopted a new law that is commonly referred to as shall issue. And the shall issue laws brought some dramatic changes to the law and, as a practical matter, to the number of people who were leaving their homes with firearms. Under a shall issue system, if any citizen can meet certain objective criteria, such as like you're older than 18 years of age, you pass a criminal background check, you passed a gun safety course, you don't have a history of alcohol or drug abuse problems. If you meet these objective criteria, then the concealed carry permit shall issue to that person. That's why it has that name. Critics of the shall issue laws said that crime would spike and we would soon see people shooting at one another over petty disputes and arguments. But that did not happen. Crime did not go up, it actually went down. And criminologists to this day argue among themselves as to how much of the decrease in crime can be attributed to these shall issue laws. Florida has issued, according to my research, more than 2 million concealed carry permits since 1987, and less than 1% of those permit holders have had their permits revoked because of misconduct by the permit holder. More than 30 states have followed Florida and adopted shall issue permit systems, and so there are now about approximately 10 million people in the United States who have concealed carry permits. Now, Florida's stand your ground law came along in 2005, and I know our panelists are going to get into a little bit more detail, but the law basically did 2 things. First, it says that there's no duty to retreat in the home invasion situation or in situations where a person comes under a criminal attack in a public place. The second thing that the stand your ground laws do is they provide for immunity from criminal and civil liability for persons who are covered by the law. And about 24 states have followed Florida and enacted similar provisions. In some jurisdictions, it's called the Castle Doctrine. In other jurisdictions, it's stand your stand your ground. Now, some critics of the stand your ground law, you may have seen this in the papers recently, they call it the shoot first, ask questions later policy. Some police officials have criticized the stand your ground as being misguided and dangerous. They point to the Trayvon Martin shooting and say that the stand your ground law has encouraged vigilantes to profile African American men, and they point to an increase in justifiable homicides to show that stand your ground laws have led to problems and unintended consequences. The defenders of stand your ground say that that law does not apply to the Trayvon Martin case and that the law protects innocent gun owners from overzealous prosecutors and ruinous civil litigation. Our first speaker today is Mr. Clayton Cramer. Mr. Cramer is a historian, and he has written several books on the right to keep and bear arms. His books and law review articles have been cited by the U.S. Supreme Court and several other courts around the country. Mr. Cramer recently co-authored this Cato paper, which we titled Tough Targets. I hope you picked one up outside. This paper explores the manner and circumstances in which civilians use guns against criminals in self-defense. I think one of the most important points made in that paper was that news organizations tend to report on the incidents where crimes are used in criminal incidents, but they usually do not report the instances where guns are used to stop criminal attacks. And that's because most often the gun is never fired. And from the standpoint of a news editor or a news producer, when that type of situation happens, let's say a criminal just runs away because he finds out that his intended burglary victim has a gun and he runs away from the scene. No shots fired, no injuries, no suspect in custody. So from the standpoint of a news organization, they just don't have much to write about, so it's not reported. And yet it's been estimated that these types of incidents, stopping crimes, happen hundreds of thousands of times a year in the United States. But again, we just don't tend to hear about them. I should also mention that Mr. Cramer was instrumental in exposing the work of a disgraced academic by the name of Michael Belial. Some of you might recall that Mr. Belial was the history professor from Emory University who won several awards for his 2000 book called Arming America. At the time, it was a very controversial and bold thesis where he said that actually gun ownership in America was quite rare up until the time of the Civil War. Mr. Cramer came forward to challenge many of the claims made in that book, and as the weeks and months and years passed, it turned into an academic scandal because the author was not able to support his claims and sources. So his awards were rescinded, his publisher dropped him, and he lost his position at Emory University. So that's one thing that you see Mr. Cramer's name come up in the news as regarding to that incident. Mr. Cramer teaches history at the College of Western Idaho, but he said that's only his part-time job, the job that he loves. The job that really pays the bills is the one in which he writes computer software for the state of Illinois. Please welcome Clayton Cramer.
Idaho.
Oh, sorry, Idaho.
I should mention also that I've had some books published in areas besides gun rights, books on black history as well. That was one of my other specialties in grad school. Well, my presentation today, of course, is concerning stand your ground laws and why they represent a delicate balance of competing interests for justice. First of all, let me explain. Castle doctrine and stand your ground laws are actually a lot more closely related than many people realize. Both of them create a legal presumption in favor of a person who's using deadly force. Both substantially reduce prosecutorial discretion in deciding whether to bring a criminal charge. And both have been growing over the last 35 years for a variety of reasons, both actions of state legislatures and also actions of the courts themselves. Castle doctrine creates a presumption that if a stranger forces entry into your home, that they intend to kill or cause great bodily injury. And to my knowledge, in every American state, that is the legal requirement for justifiable homicide, that you have reason to fear being murdered or suffering great bodily injury. So these laws mean that a resident who uses deadly force against a stranger who forces entry starts out with a very strong legal advantage. A prosecutor can still pursue a criminal charge against the person who shoots an intruder, but the deck is now stacked against the prosecutor, who has to prove that the shooter knew that the intruder meant him no harm. Another way of looking at it is that castle doctrine stacks the deck in favor of a person who was minding his own business when a stranger forced entry. Now, closely related to stand your ground laws, which have at their core the idea that you have no obligation to retreat from an attacker in your home before using deadly force, is this idea of stand your ground, that even outside your home that you should not have an obligation to go ahead and retreat. And this term stand your ground comes from a U.S. Supreme Court decision, Beard versus U.S., 1895, which held that a person was not required to retreat before using deadly force. Of course, this assumes that you're not the aggressor, that you were minding your own business. And of course, it also assumes you have a right to be where you were when you were attacked. That, if you were trespassing or in some other way breaking the law at the time that you were attacked, you would not be in anywhere near the same situation. Where does this notion of a duty to retreat come from? At common law, you were only allowed to use deadly force, in the word of Blackstone's commentaries, for the prevention of any forcible and atrocious crime. Crimes like robbery, murder, rape, breaking into a house at night. These were the cases where deadly force was allowed and was recognized as being completely acceptable. But there are circumstances that were a bit less clear, that the common law did not handle very well. What if a stranger walked up to you on the street and punched you in the nose and started beating on you? What if several strangers attacked you or surrounded you and started menacing you? Until 1532, if you drew your knife or your sword and killed them, or just a lucky punch against an attacker caused that person's death, this was technically a crime. Your property would be confiscated, and you might well be convicted of manslaughter and punished by branding in the hand. Now, these circumstances were actually pretty common, these sudden brawls and attacks. In fact, medieval and Renaissance England was actually worse than Detroit today in terms of the levels of violence. So your only hope, if you ended up killing someone under these conditions, was to beg the king for a pardon. And if you had good reason for what you had done, and of course you got a lawyer to represent your case before the courts of chancery, you could get that pardon, but your property's gone. Obviously unjust. And so what happens is that, and also juries are refusing to convict, so Parliament passes a law in 1532 that adds to the category of excusable homicide what they called homicide se defendendo, which is one of those horrible Latin phrases. And this was the situation where you were attacked in the course of a sudden brawl or quarrel, and you ended up killing your attacker. Now, the defense was not available if you had a safe or convenient way to back away from the attack. You could not use this defense if you initiated the confrontation, or if you had a chance to stop fighting and could have backed away but chose not to. So the goal here is to discourage killing. Now, this was an affirmative defense, meaning that burden of proof was on the person who was using the defense. The prosecutor didn't have to prove anything here. You, as the person making this defense, had to prove that you had reason to be concerned. Now, this is a little bit at variance with our laws today, and there are people who say the American tradition of violence plays a part in this. This 1850s illustration from Harper's captures well the sort of pointless and stupid brawling that was in some parts of the United States, especially in the South, a big part of the culture. You've probably never seen a roast pig used as a weapon before, have you? The historian Richard Maxwell Brown wrote a book some years ago called No Duty to Retreat, in which he made the claim that this violence that was common in American society and a general focus on manliness had caused our courts to abandon this duty to retreat contained in the 1532 law. And there's some debate about whether he actually had this correct or not. Even today, English law is not really consistently following a duty to retreat. There's a case I found called Rex v. Byrd from 1985, where the English Court of Appeals ruled that a woman who took out an attacker's eye with a shot glass was not obligated to retreat before using that level of force. And she had actually provoked the attack. It was an ex-boyfriend. They met at a party. She poured a drink over him. He shoved her into the wall. She had a glass and took out his eye. So even English law is not completely consistent on this. So perhaps this isn't something that we actually innovated on the English law. Now, even states that you might think of as NRA-occupied territories have at least in some places, abandon this duty to retreat. California Penal Code Section 195 here, you can see it on the screen, defines excusable homicide in terms that are quite similar to that 1532 statute by the English Parliament. But there's one significant difference, and that is no duty to retreat. And the courts in California, starting as far back as 1895 with People v. Hecker, have recognized that there was a right to stand your ground. And this seems to be the case in a majority of states, that there is some recognition that at least under some conditions, there is no duty to retreat to enjoy the excusable homicide statute. Even states that recognize a duty to retreat in a public place often do not require this in your own home, even when the attacker is someone else who lives in the same house. And that actually leads to an interesting discovery. Some of what has driven this abandonment of the duty to retreat, and abandonment even by the courts, even without legislative action, has been domestic violence situations. There's a number of state Supreme Courts that have recognized that there is no duty to retreat before using deadly force in your own home, even when the attacker is not a stranger. I've given you a list of a few representative examples. State v. Livesey from my state of Idaho, not Illinois, involved a woman who had shot an abusive husband. He had been locked up overnight in the county jail. He came back in the morning, attitude not improved. She fired one shot as a warning to let him know to back off because he was threatening her at this point. He was not good at taking subtle hints like that, and he shoved her into the wall. She shot him either by accident or as a result of intent. It was somewhat unclear. And at trial, the instructions given to the jury were that she had a duty to retreat even out of her own home rather than use deadly force against this drunken brute. And the state Supreme Court ended up saying, no, that's not right. And so there's been a number of other states that have recognized that there's no duty to retreat out of your house. Now, I mentioned that castle doctrine and stand your ground laws are closely related, and sometimes they're so hopelessly intermingled that I have a hard time seeing them as completely separate. Because of the controversy concerning Trayvon Martin's death, and Florida's law has become something of a model for other states, I'm going to go ahead and tend to focus on that. First of all, the stand your ground law in Florida is primarily a castle doctrine law. Most of the text is about protecting your ability to defend your dwelling, residence, or vehicle from an attack. Use of force against trespassers is allowed, but not deadly force. And it's interesting, the first use of Florida's stand your ground law that I saw when, for example, the data that we put together for this report here, involved a woman named Marilyn Caraway. She shot her ex-boyfriend when he forced his way into the screened-in porch part of her home. There's only a small part of Florida's stand your ground law that protects the right to use deadly force in other places. And even then, the use of deadly force is authorized only, and you'll notice the language here, reasonably necessary to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. So I'm having a little trouble seeing this as a really radical change in terms of when it authorizes the use of deadly force. Now, you're probably wondering, if this is not such a radical change, why is it even necessary? In an ideal world, it wouldn't be necessary. The problem here, unfortunately, is prosecutors have an enormous discretion in deciding whether to pursue criminal charges. And obviously, in a legitimate case of self-defense, you would expect a prosecutor to not go ahead and file charges. Even if there's some ambiguity, you're going to tend to give the benefit of the doubt if you believe this person probably went ahead and was engaged in a lawful self-defense. The problem is prosecutors sometimes abuse their discretion. I hope that doesn't surprise anyone. Sometimes they're currying favor with voters, or at least some voters. As we saw with the Duke LaCrosse rape case a couple of years back, prosecutors are not above violating the law in order to get votes. The district attorney, Mike Nifong, was in the middle of a primary, and he needed a lot of votes that he otherwise might not have gotten. Eventually, you recall, he was disbarred for dishonesty, fraud, deceit, and misrepresentation, and even served, I think, 1 day in jail. Sometimes prosecutors have such a fierce opposition to gun ownership that they pursue criminal charges simply because the victim used a gun. Or perhaps the prosecutor wants to be seen as tough on crime. Now, some of the early adopters of these sort of laws did so because of prosecutorial abuse of discretion. For example, California's Home Protection Bill of Rights, which is a Castle Doctrine law, this passed a democratically controlled legislature in 1984 by huge majorities in both houses. In the state Senate, my state senator was one of only 3 out of 40 to vote against it. No one is going to mistake California's legislature back then for NRA puppets or even neutral on gun ownership. So what provoked it? What got them to pass this bill so overwhelmingly? My recollection of newspaper coverage at the time was that the LA County DA went ahead and prosecuted a woman who had shot a guy who had forced entry into her home. Now, he didn't get very far on that, but of course it was expensive. I talked to the author of the bill a few days ago, and he remembers that there were a number of such incidents that had come up, and this is why the legislature was so willing to go ahead and change the equation, to go ahead and change the balance on this to create this presumption in favor of the homeowner. Now, the author of Florida's Stand Your Ground law says that the particular event that provoked it was a man shot an intruder who had forced entry into his motorhome. He was living in a motorhome on his property after, Florida has these hurricanes come through every few days and destroy everything. It had destroyed his home, and he was living in this motorhome and shot the guy that forced entry. And it took many months for the prosecutor to decide, I'm not going to pursue this. And of course, in the meantime, remember, the cost of defending yourself from prosecution will bankrupt you if nothing else does. What effects have these laws had on crime rates? Well, the Stand Your Ground laws are really a little too recent to have any long-term longitudinal effect studies, but there is a little bit of work done on the effects of Castle law. Dr. Lott's More Guns, Less Crime mentions statistically significant reductions in the rates for a number of the common crimes like murder, rape, robbery, and aggravated assault, although he's also careful to emphasize that the number of years and the number of states is so small that you might not want to draw too much meaning from this. Now, the April 7th Washington Post reported that after Florida adopted their Stand Your Ground law, civilian justifiable homicides tripled. Now, at this point, we're all supposed to go gasp. And it was apparently a significant increase from 12 per year average to 36 per year average. But the same article also mentioned that police justifiable homicides also tripled over that same period of time. And I don't really see how the Stand Your Ground law would have affected police justifiable homicides. Perhaps, in fact, the justifiable homicides increased because of an increase in aggressive criminal behavior. Now, there's one rather interesting quirk about the way the justifiable homicide data is gathered. It turns out that the FBI, who gathers this data from every state, they exclude the excusable homicides, and they only include justifiable homicides based on the initial reports by the police. If there's a later investigation by the police, by the prosecutor, by grand jury, or at trial, and that killing is ruled justifiable or excusable, the FBI's data does not get updated. And it's very likely, since the same people in Florida that gather this data for the FBI are what Washington Post is using, it's very likely that that data is not being updated either. So it may be that not that there's actually been an increase in justifiable homicide, maybe it's just being reported much more early in the process as justifiable than it did before. Now, in 1989, Time magazine produced what I call a very useful piece of propaganda. And it was useful because of the amount of actual raw data that it contained. They devoted most of the magazine one week to what they called death by gun. As best they could, they got information on every person killed with a gun in the United States during 1 week. 464 deaths, 199 criminal homicides, 13 justifiable or excusable by police, 14 justifiable or excusable by civilians. But what happened when they went back a year later? They did a follow-up, and they discovered that 14 of those cases initially reported as criminal homicides were now actually justifiable homicides. So at least a doubling of the justifiable homicide rate as all these cases actually worked their way through the criminal justice system. And there were still some of these criminal homicides that have not gone to trial, so that might continue to change. Criminologist Gary Kleck at about the same time was collecting studies that demonstrate that this is probably on the low side. There are an awful lot of cases where women kill intimate partners, and they're often charged with a crime, manslaughter, for example. and are later found innocent. These are complicated situations, and I'm not surprised that police often initially charge these as crimes, even though later investigation concludes, yes, this woman had sometimes this man had a reason to go ahead and use deadly force. So, did the justifiable homicide rate actually triple? Or was it just crimes that otherwise would have been reported as murder or manslaughter and then later figured out were more likely to be reported as justifiable homicide at the very beginning? I don't know for sure, but I do think is at least a plausible explanation. Now, stand your ground laws move the balance point of the criminal justice system. There are prosecutors who argue that these laws make it too hard to prosecute criminals who shoot people or kill them in general. The claim is that criminals use these presumptions that are being built into these stand your ground laws to get away, literally, with murder. And I don't doubt that this does on occasion happen. A lot of violent crime, remember, involves criminals killing other criminals. People that are arrested for murder usually have very long rap sheets. And victims often have disproportionately long rap sheets as well. Sometimes they're completely innocent people, but sometimes they're bad people killing bad people. On the plus side, it makes it harder for prosecutors to use the enormous powers that their position includes to abuse those who are engaged in lawful self-defense. And I think what we really have here is a question of balancing the interests of justice. At what point does a law give too much benefit of the doubt to a person engaged in self-defense? In states that have very little violent crime, such as where I live in Idaho, a stand your ground law is probably unnecessary and could even be harmful for the reasons that critics give. In states that have severe violent crime problems, where people have good reason to fear being attacked on the street, stand your ground laws may make very good sense indeed. Now, I cringe at the abstract idea of a stand your ground law because it will encourage people to use deadly force. The world's full of stupid teenaged punks. I hope this is not a surprise to anyone here. They get mouthy, they get aggressive, they rely on intimidation when they aren't actually being violent. Some of them, a few days in jail, a fine, might be enough to make them stop being punks. At least we can hope that. And they aren't going to get that chance if they attack someone on the street who ends up killing them. But when I look at Florida's stand your ground law, it doesn't worry me all that much. It seems pretty carefully drafted. Outside of your home, where does it apply? You must be in a place you have a right to be. You cannot be engaged in an unlawful activity. So if you're a drug dealer, you don't get the benefit of it. You are allowed to meet force with force, so roughly equivalent to what's being used against you. Someone pushes you, you can push them back. Someone pushes you, you don't shoot them. You are allowed to use deadly force under a rather limited set of conditions. You have to reasonably believe to prevent death or great bodily injury to himself or herself, or prevent the commission of a forcible felony. You do not get the benefit of this law if you are in the process of committing a forcible felony or trying to escape after doing so. And if you initiate the confrontation that leads to someone's death, you don't get the benefit of the law under these set of conditions. You can use it if you believe you're in imminent danger of death or great bodily harm, and you've exhausted every reasonable means to escape such danger, or you have withdrawn from physical contact and indicated you want to stop the fight. So if you started the fight, a lot of limitations on your ability to use deadly force. So my argument is there may well be flaws in the stand your ground law that Florida has and that other states have as well. But I'm not seeing any clear evidence that this is a severe problem. I'm not seeing any evidence that this is a systemic problem. There may well be cases that require some adjustments to the law. I do not see that the core of the law is fundamentally at flaw here. Thank you.
Our second speaker today is a well-known authority on firearms, police work, and the rules pertaining to self-defense and the use of deadly force. For 37 years, he served as a part-time sworn officer in New Hampshire, where he is currently serving as a captain. He also serves as a police prosecutor in that state, and in that capacity, he teaches attorneys in their continuing legal education. They earn credits on topics related to the use of force and justifiable homicide. Over the course of his career, he has trained thousands of police officers and civilians in weapons tactics and survival techniques. He's a prolific author He's written thousands of columns over the past 30 years in periodicals such as The American Handgunner and Guns Magazine. He's also written many books. The most relevant one to this forum, I think, is his 1979 classic and bestseller, In the Gravest Extreme, which was about the use of guns for self-defense, widely endorsed by police officers, lawyers, and even judges. When he's not training others or writing articles, chances are he's out on the range competing somewhere. He is a champion pistol shooter, winning competitions all around the country. I should also mention that he has himself been involved in more than 20 armed encounters over the course of his career. With that background, I don't think you'll be surprised to learn that he is one of the most sought-after experts to come to trials to testify on shoot and don't shoot situations, self-defense cases, and the use of firearms in cases involving police officers and civilians. Please welcome Massad Ayoob.
I'd like to thank Clayton Cramer for an absolutely outstanding historical perspective on this concept. As he pointed out, the Castle Law or the Castle Doctrine and the Stand Your Ground laws are very similar, but they're subtly different. There's been a lot of confusion over the two in the last few years as these laws have spread, and that is magnified to the power of 10 in the last 2 months after the currently ongoing controversial shooting in Sanford, Florida. Perhaps the reason is the law being debated there. You want to Google Florida Statute 776.013. As written, actually encompasses 3 different concepts. Certainly the Castle Doctrine, as Clayton explained, going back to the English common law, the citizen's home is their castle. Attacked there, they need not retreat before using appropriate force to repel the attacker. The Stand Your Ground law is distinctly different because that covers the individual if they're assaulted in a public place. Some of the confusion has come from the fact that even some of the sponsors felt since now we'll be able to do on the street what we could do in the home, we use the term for it that we used in the home, Castle Doctrine. Muddying the waters further, that particular statute also encompasses a presumption of reasonableness. Now, just as we all have a presumption of innocence, that is, we're innocent until proven guilty, that particular law is written says the person who makes a claim of self-defense, if they can prove it is a reasonable claim of self-defense, if they can show to a preponderance of evidence standard, that is, more likely than not that they're telling the truth that it was self-defense, the case should be dismissed. This has created a great deal of ire and a great deal of controversy. I've heard the argument that, well, you shouldn't allow this because all the bad guys will say they shot their victims in self-defense and get off. Ladies and gentlemen, the bad guys have been using that excuse as long as there have been bad guys. I shot him in self-defense. Some other dude done it. I don't know a thing about it. I didn't beat him, and I'll never beat him again if you let me go. Basically, through all that time, skilled investigators and skilled prosecutors like the man at my left have torn those BS arguments apart and won the convictions as they should. What the Stand Your Ground law does is keep the innocent citizen who's telling the truth that they did shoot in self-defense from going through the kind of legal nightmare that Clayton Cramer just described to you. I've been an expert witness for the courts in shooting cases and weapons cases since the year 1979. I can point to people who, by the time they were finally acquitted, had paid 6 figures in legal fees. People who've lost their jobs, and we'll talk in a minute more, it goes beyond the financial. You'll hear the argument, well, we shouldn't allow Stand Your Ground because it makes the police's job more difficult and it makes the prosecutors more difficult. I submit to you that that is not true. The burden that the prosecution has is to show that you are guilty beyond a reasonable doubt, a likelihood in the high 90th percentile. For you to get off on presumption of reasonableness, you have to show to a greater than not certainty level, preponderance of evidence, 51%, 50.1%, whatever the given law professor may quantify it as, that you did the right thing. Do the math. If you have been able to convince a judge at hearing that it's more than 50% likely you're telling the truth and you acted in lawful, justified self-defense. How on earth is any honest prosecutor who ever lived going to turn that around in a convincing, the same impartial judge or jury that, nah, he's 98% likely that he did wrong instead of right? In essence, it's not going to change anything. If anything, it may literally be more cost-effective and more efficient, as well as simply more just for the legal system. If within a matter of weeks after charging, a hearing determines that, yep, more likely than not, this guy really did shoot in self-defense, and that's what the evidence shows, it's done. We've preserved our fiduciary duty to the taxpayers not to squander their money in a trial that could last for weeks or even months, in a world where it costs thousands of dollars a day to keep that courtroom open, where it costs hundreds of dollars an hour for you, the defendant, to pay for your defense attorney. We hear people say, well, this law says you can shoot anybody if you feel the least bit scared of them. Anyone who tells you that has told you they never read the law. Google that statute. Look in any of the states, and these are the majority of the states, as Clayton told you, that have the stand your ground principle. It doesn't say you can shoot because you're scared, because you're nervous, because you had mere suspicion. You'll have to show that your action was reasonable. Now, what you want to do in the Florida statute says reasonable. It doesn't show you how to find reasonable. So you do a Google search for the Florida jury instructions, and you'll find out that just like every other jurisdiction in the country, they use another English common law doctrine called the doctrine of the reasonable person. That's essentially a three-pronged test. The trier of the facts must ask themselves, what would a reasonable and prudent person have done in the exact same situation as this defendant, knowing what this defendant knew under the circumstances? So if anyone tells you, gee, this law says if somebody looks at you cross-eyed, you can shoot them, they're telling you they never read the law. They're telling you they don't understand the concept. Basically, this has not been a huge sea change, as Clayton explained. Even in the states that still have the so-called retreat requirement, again, we need to read the fine print. Nowhere in this country has retreat ever been demanded unless it could be accomplished with complete safety to oneself and to others. Those others being those within the defendant's mantle of protection, their family, their customers, in a robbery of the store that they owned, something of that nature. We've got, about 100 people in here? Let me ask you a question that I've been asking my students for many years. Can any of you think of a situation where you would shoot a human being to death if you could have simply walked away and retreated in complete safety to oneself and others, without trying to outrun a bullet, without trying to turn your back on a drawn knife, without trying to walk backward faster than another human being can walk forward? I see no hands. Don't feel bad. No one else has ever been able to answer that question for me either. It's not a change in how things are done. We're allowed in this country to use lethal force to defend ourselves, our families, our loved ones, when we're in situations of immediate, otherwise unavoidable danger of death or great bodily harm to ourselves or to others within that mantle of our protection. Historically, it's been a three-pronged test to determine whether that situation existed. And different jurisdictions, different police academies, different training schools will use different terminology. But basically, the three factors are most commonly known as ability, opportunity, and jeopardy. Ability means your opponent has the power to exert deadly force, that is, to inflict a fatal injury or a crippling injury. Often that will take the form of a per se weapon, the knife, the club, the pistol. It can also take the form of disparity of force. Disparity of force is a category of situations where the unarmed attacker has such a physical advantage that he's so likely to kill or cripple the armed person that that advantage becomes the equivalent of a deadly weapon and allows his intended victim to respond with deadly force. We can see examples in this room. Anyone in here with a physical handicap, attacked by an able-bodied person, is facing disparity of force, and in a true violent attack is authorized to use a deadly weapon in self-defense. As a general rule, the female attacked by the male, because society recognizes males tend to be larger, have greater upper body strength, and have been accultured to be more aggressive. We spoke of the physical handicap. That can also be a handicap that occurs in the course of the fight. You're an able-bodied man in prime of life, but in the course of the fight, the other man has been able to break your kneecap. Now you can't move away from him. Now you can't fight back on an equal force level. At this point, we've reached deadly force level for you to respond with. It could be something as simple as position of advantage. The two of you are exactly the same height, weight, physical skill. But the other man manages to get you down and he's banging your head against a rock. Or the other man gets you down and he's stomping you. A kick that before might have broken a rib, when you're down on the ground, now becomes lethal force. Because if you've ever read in certain law books that are laws of states that a shod foot is a deadly weapon. Doesn't mean a guy kicking you in the butt. It means if you're down and being stomped. If my colleague on the left throws a punch at me here, I can slip the punch, I can roll with the punch, but if he gets me down, I can't do either of those things. And now my head here is caught between the underlying ground and the crushing force of his whole body weight. And in that situation, his position of advantage becomes the same as a deadly weapon and would authorize me to draw my gun or knife in self-defense. Force of numbers is an extremely common example of disparity of force. The single individual attacked by 2 people, 3 people, 4. So that would be the ability element. The opportunity element means capable of immediately employing that power. If someone up there in the back row was threatening to stab me, I'd certainly be concerned about it, but he has a great distance to travel. He has to get past several rows of seats, and he has to get past several people who, at least one of whom I hope, would stop him from stabbing the poor little old man. But if instead he's up here with us, nothing in between us, the tests have shown since the pioneering work of Dennis Tueller in 1983, the average adult male from a standing start can close a distance of more than 20 feet and stab their victim in an average time of 1.5 seconds. So in that situation, the opportunity factor would be in. And finally, the third element, jeopardy. Jeopardy means his words and or actions manifest an intent to cause death or great bodily harm as it would be interpreted by any reasonable and prudent person such as yourself. When those 3 things come together, deadly force is warranted in self-defense. It happens very frequently in this country. The stand your ground laws were promoted by the people who recognize that and by the people who have seen the ironic tragedy of someone who defends themselves, defends their family, preserves themselves from a murderous attack to come home to their loved ones, suddenly having to go through the ordeal, both criminal and civil, of being painted as the murderer, as the reckless slaughterer of men. Let me close briefly because I don't want to take too much time here. We're not talking ancient history. We're talking things that have happened recently. Case in point, in West Des Moines, Iowa, October 29th of last year. A man named Jay Lewis, middle-aged guy, federal employee, works in an office, clean criminal record, so clean he has a license to carry a concealed handgun in public, is attacked on the street by 2 men of another color. They decide it would be an excellent idea to physically assault him. He draws his gun. He orders them vehemently to stay back. They lunge. Disparity of forces in play. He fires. 1 man is shot across the pectoral muscle into the bicep and wounded, and the 2 of them decide, you know what? It's not fun being 2 coyotes on a bunny when the bunny shoots back. We're leaving now. Does anybody have a problem with that act of self-defense? Jay Lewis, the man who fired, was African American. His two attackers, including the one who was wounded, was Caucasian. The topic of race as it affects criminal justice in America is the topic for another day, at least for me. Jay Lewis was arrested. Jay Lewis was held on a 6-figure bond that on an ordinary working man's salary he could not afford. He stayed there rotting in jail. Meanwhile, the folks who owned the apartment building where he lived served a notice that said, "Ooh, we understand you've just been arrested for shooting someone. You are altogether too scary and dangerous to live among us. Consider yourself evicted." And they mailed it to him at his apartment address and posted it on his door at his apartment when they knew or should have known that he was in jail and could not receive them. And when he did not respond to that after the 30 days or whatever, they cleaned out his apartment, put his furniture, his clothing, his computers, including a novel he was writing, out on the front lawn to be stolen by whoever came by, and of course they all were. And after 112 days in jail, the prosecution dropped the majority of charges, took him to trial on the rest, and the jury said collectively, "Are you kidding us?" and rendered the acquittal. Does that mean the system works? To an extent it does. The man was literally homeless, damn near penniless. That's not the way justice should work. It was to prevent things like that that political activists, civil rights activists, and I consider we have many levels of civil rights activists in here. Those who fight for gun owners' rights I consider to be civil rights activists as well. I remember that Charlton Heston, former president of the NRA, marched with Martin Luther King, who was also a gun owner. But their efforts have given us the stand your ground laws in many states. They are moving now to put that law in place in the state of Iowa to prevent the kind of injustice that Jay Lewis suffered from being suffered by any of their citizens there. And for that reason, this speaker supports the concept. Thank you.
For anyone interested in learning more about Mr. Ayoob training programs, you can find more information at his website, which is massadayoob.com.